Good evening, and thank you for braving the storm and coming out. As Gabrielle mentioned, I'm going to conclude with two case studies. The first one is indeed about punitive damages and is the extension from the earlier lecture today. And then the second case I'm going to show you introduces a new topic that's called federal preemption of state tort law. Now, I think you're going to find each of these cases interesting. There are aspects of each of them that will draw together many different features that we've discussed about U.S. tort law. But there's something else, too, that draws these two topics together. So the first thing to say is that each of these cases is coming from the U.S. Supreme Court, our highest constitutional and federal court. That is, in and of itself, somewhat unusual for a discussion of U.S. tort law. Why do I say that? Well, in the United States, as you know, tort law is a state law. So we have 50 different states and Washington, D.C. and territories, and each of them can have their own common law rules of tort. There's remarkable consistency. It's not that we have 50 different rules for things, but we do leave it to the highest state court to decide what the tort law rules will be. So why are we talking about the U.S. Supreme Court, which is our federal and constitutional court? This, I think, is an interesting development because it shows something that I've written about before, which is the federalization or nationalization of tort law in the United States. So even though we have state-by-state standards for tort law, there are certain issues that the U.S. Supreme Court has become very heavily involved in. So these are two issues. One, punitive damages, and then the second, this issue of federal preemption of state tort law. So punitive damages, I mentioned at the, maybe I should, I mentioned, I'm just going to go back a minute. Whoops. No, not that far back. Sorry. I mentioned at the very end of this morning's lecture this case, BMW of North America versus Gore. This was a seminal case from the U.S. Supreme Court decided in 1996, and it was this case, it was the first time the U.S. Supreme Court struck down a punitive damages award that had been affirmed all the way up through the state appellate process. This was happening in Alabama, and in this case that the Supreme Court took, that was the first time that it articulated, as we discussed this morning, these three guideposts. And what the U.S. Supreme Court was trying to say is that there's a constitutional issue when it comes to punitive damages, that if you extract a large punitive damages award against a defendant, it could be constitutionally excessive, it could violate the defendant's constitutionally protected rights. And the way the U.S. Supreme Court directed lower appellate courts was to say punitive damages are a state law remedy, and it's fine for you to be in your state having punitive damages. However, the lower courts have to review those damages to make sure they're not constitutionally excessive. Now, in directing the lower courts as to what would amount to constitutionally excessive, they gave these guideposts. So the first was the courts were to look at the reprehensibility or egregiousness of the conduct. And if conduct was very egregious, then higher punitive damages award was warranted. The second was to look at this ratio, the relationship of punitive damages to compensatory damages. As you saw from this morning in some of the charts that I showed, many state courts had already set up a system of such ratio review. They had set limits on punitive damage of a 3-to-1 ratio and the like. The U.S. Supreme Court said there's not a mathematical rule. We can't say that punitive damages should only be 3-to-1 or 4-to-1, 4 times compensatory damages. However, they did say that a single-digit ratio would be more likely to be constitutional. And then the final guidepost was to look to comparable penalties and statutes. So this was in 1996, and the U.S. Supreme Court's next case in this important line of cases about punitive damages is the one that I want to do as a case study. It's called State Farm Mutual Automobile Insurance Company versus Campbell. So first, about the facts, there was an underlying tort action in this case. It was an automobile accident, and the facts of that are that Curtis Campbell, who was the defendant in the original tort action, was driving his car, and he was on a 2-lane highway. He was in a hurry, I guess, so he passed 6 vans that were driving ahead of him going on the other side of the road, right? So he was on the side of the highway with the oncoming traffic. And this other gentleman, Todd Ospitall, was driving a small car coming the other direction. So Mr. Ospitall, in order to avoid a head-on collision with Mr. Campbell, swerved and hit another driver. So it was a bad car accident, which ended up with Mr. Ospitall being killed in this car accident, and Mr. Slusher, who was the car that he collided with, was permanently disabled. Mr. Campbell, who of course was at fault for this accident, emerged without any injuries. So he was okay. There was an individual that he had hit, or the individual who swerved to avoid hitting him was killed, and this other car driver was in bad shape. Mr. Ospitall and Slusher brought a tort and a wrongful death action against Mr. Campbell. Mr. Campbell insisted, sort of contra the objective facts, that he was not at fault. But there was a very early consensus by investigators who came to look at the scene of the accident and witnesses that Mr. Campbell had been negligent. It was his unsafe maneuver going into the oncoming traffic that caused this accident. Mr. Campbell was insured, as automobile drivers are in the United States, by State Farm. And he had an insurance policy for $50,000. So State Farm decided that they would go to trial and contest the liability of Mr. Campbell. And the other side, Mr. Ospitall and Slusher, their attorneys had asked the insurance company to settle with them. And they only asked for the limits of the insurance policy, the $50,000. As I've mentioned before in a prior lecture about how insurance seems to drive tort litigation, this is an example where the plaintiff's attorneys find out what's the limit of the insurance policy, in this case $50,000, and that becomes their demand. So although this looks like a quite irrational decision, especially after the fact, when I tell you what happens next for State Farm to have refused to settle at that amount, to make an argument in State Farm's defense, what many insurance companies say is that the situation is such that every plaintiff's attorney who finds out what the limit of the insurance policy is will demand that amount. And the defendant, the insured, will be happy to have such a settlement because none of their personal assets would be at risk. And so the insurance company feels as though it has to be on guard, that it's being, that its interests might be adverse to the insured. This was one of those situations I mentioned in my lecture about how, given the ubiquitous nature of insurance and how it drives tort litigation, we have to be aware of these potential conflict of interest that can arise between the insured and the insurance company. But let's see what happens next. They go to trial, and a jury determined that Mr. Campbell was 100% at fault. It was pretty clear that it was his dangerous maneuver that led to this accident, and the jury returned a verdict of $185,000, which was, of course, about $135,000 more than the limits of the insurance policy. At that point, we've talked about how there's conflict here with the insurer, because at this point, State Farm refused, even though they were the ones who wanted to trial, State Farm refused to pay that excess. They were going to pay only $50,000, and Mr. Campbell was going to be responsible for the remaining $135,000. In fact, State Farm said to Campbell, who didn't have these assets, well, maybe you should put your house up for sale. So that was sort of State Farm's treatment. During the appeal, this is what's interesting and what happens next, is Mr. Campbell decided to reach an agreement with Messrs. Slusher and Ospital. Remember, they were the plaintiffs below, and what they decided was that the plaintiffs would not seek satisfaction of their verdict against Mr. Campbell. They wouldn't seek to go after him for the $135,000. And in exchange, Mr. Campbell said that he would pursue a separate tort action and sue the insurance company. The insurance company he was suing on a bad faith failure to settle. That was his claim against the insurance company. But what he agreed is that Mr. Slusher and Ospital's lawyers, namely the plaintiff's lawyers in the action below, would represent him against the insurance company. So the situation changed quite rapidly, and Mr. Campbell then became the plaintiff suing State Farm. They also decided that in that action, even though it was Mr. Campbell suing the insurance company, that Slusher and Ospital and their lawyers would be the ones making the decision. So in other words, there could be no settlement. Mr. Campbell could not settle his own action with the insurance company without their approval. So in essence, he's sort of the stand-in for this litigation, but it's going to be driven or controlled by the plaintiff's attorneys from below. And finally, this is very important, Mr. Slushital and Ospital would receive 90% of any verdict that Mr. Campbell got against the insurance company. I should tell you, this is the very scenario that the insurance companies fear, right? They fear that in a tort lawsuit below, the plaintiffs will sue the defendants for the maximum of their, and request the maximum of the insurance policy, offer to settle at that amount, and then if the insurance company refuses settlements, the two parties who are adverse below would join together and sue the insurance company for bad faith failure to settle. And that's exactly what happened. That's the underpinnings of this case. The Utah Supreme Court, this was all happening in the state of Utah. The Utah State Supreme Court denied Mr. Campbell's appeal in the underlying tort action. Because remember, all of that first tort action was being appealed while the plaintiff's attorneys decided to join with Mr. Campbell to sue the insurance company. At that point, but it was a year and a half after the first jury verdict was reached, State Farm did pay. They paid the entirety of the judgment. They paid the entirety of $185,000. But that had happened. There was a period of time, about a year and a half, where Mr. Campbell alleged he was under extreme emotional duress, right? So if you ask the question, which is a good one, in the suit that Mr. Campbell is bringing against his insurance company, what are his damages? At this point, the insurance company has paid out the entirety of the judgment. But Mr. Campbell's claim was that he suffered emotional damages and feelings of insecurity for the year and a half period when he thought he was going to have to put his house up for sale or do something to pay this judgment. So that case is the one that eventually went to trial, Mr. Campbell's case against the insurance company. And in addition to being awarded economic compensatory damages, there was a punitive damages claim. So Mr. Campbell filed his complaint. He alleged bad faith, failure to settle. He alleged fraud, and he alleged what we call intentional infliction of emotional distress. So these are all intentional torts, and given that they're intentional torts, in addition to filing that action, he claimed punitive damages as well. So the jury in this action gave Mr. Campbell $2.6 million in compensatory damages and $145 million in punitive damages. At this point, State Farm is wishing they had settled that underlying action for $50,000, right? This was seen as a huge award. The jury, if you look at the trial transcript, etc., was clearly very angered at what they saw was a pattern and practice on the part of State Farm doing this kind of behavior, failing to settle actions where they should have, failing to come to the aid of their insured. So there was a lot of evidence that went before the jury about situations all over the United States where this national insurance company was behaving egregiously vis-a-vis its insureds. So that's what led to the jury's award. The trial judge reduced these awards. He reduced them to $1 million in compensatory damages and $25 million in punitive damages. So remember, at this juncture, another point I want to highlight is this is a fairly typical scenario when a jury gives a blockbuster, very large award. The trial judge, who has sat through all of the same evidence, etc., has an opportunity to limit those awards even before there's any kind of appeal taken. So the trial judge reduced these damages. Interestingly, though, this was a situation where it gets appealed up through the state appellate process, and usually the typical story, the one I was talking about this morning, is through those levels of appeal, the appellate courts put further restrictions because they're following the U.S. Supreme Court guideposts, so they're looking at reprehensibility, but they're also looking at the ratio between punitive and compensatory. And so here it was a 25-to-1 ratio, which looked higher than what the Supreme Court had said they had, the U.S. Supreme Court had in mind. But lo and behold, the Utah Supreme Court didn't reduce the punitive damages, but reinstated the original award. At that point, the parties petitioned the U.S. Supreme Court to say that this is unconstitutional, the highest state court isn't following your direction, and the U.S. Supreme Court in this case did find that the punitive award was excessive, and it rested on these three guideposts for from BMW versus Gore. Namely, again, remember they said, if you look at the reprehensibility, the Supreme Court said this behavior was reprehensible. We give you that. But when we come to the second ratio about relationship of punitive damages to compensatory, that 145 to 1 ratio raises suspicious eyebrows, judicial eyebrows, is too high. And moreover, even though there are statutory penalties for deceptive practices on the part of insurance companies, those kinds of statutory fines are much lower. So they held that this could not be sustained. There were a couple other interesting comments that the court added. The first was this notion about jurisdictional overreach. And this is interesting because this is a feature that happens because in the United States we have state-by-state tort law, as I mentioned at the outset, and then we have this overlay of federal law. So the court said that a state cannot punish a defendant for conduct that might have been lawful in another state. So this is an interesting concept, right? Different states could have different ideas about what kinds of practices, particularly with respect to business practices, which types of big business practices are unlawful and shouldn't be allowed vis-a-vis consumers. Some states can be more consumer protective than other states, and so the court was very worried about a kind of case like this one against State Farm, where practices that this national insurance company was doing all over the United States in different states was brought before the jury. Because the reasoning seemed to be that a state can decide what the appropriate penalty is, how they should be handling this, but they shouldn't be deciding this issue for other states. So that was kind of an interesting principle from this. And I have to say, I was thinking about this in our panel discussion this morning, when there was some discussion about whether there is a component or a punitive element in what in Brazil is determined moral damages. In this case, Justice Kennedy, this is Justice Anthony Kennedy of the U.S. Supreme Court, in this little picture, he's the one who authored the opinion. In his opinion, he said that in this case, it looked like there was already a punitive element or component of the compensatory damages. In other words, the jury had awarded, remember, $2.6 million in compensatories. The trial judge reduced that to $1 million, and he claimed that because the tort action was in part for intentional infliction of emotional distress, it was for the distress that Mr. Campbell felt during the 18-month period when he thought that his house might have to be put up for sale, etc. The compensatory damages already included enough of a punitive element that you didn't, in that instance, need to have such a large punitive damages on top of that. So it's interesting. It suggests that even though in the United States we have these separate categories, we have compensatory damages that are subdivided by the economic and non-economic, pain and suffering, and then we have a separate category of punitive. Justice Kennedy was making the point that compensatory damages, especially when they're being given for outrage, for emotional distress, for humiliation, those might already have a kind of punitive intent or element. So, and it's almost as if the idea is if we have that there, then we shouldn't allow for it in the category called punitive damages. Okay, I want to switch gears a bit to talk about the second topic, and that is federal preemption of state tort law. So this again is a very interesting legal topic that arises in our system because we have state tort law, but we regulate many of our products through federal laws and regulations. So Wyeth versus Levine is a very important case in the United States that involves an FDA, which is the Food Drug Administration, approved. And the idea, for those of you who are with me all the way from the beginning, I began these series of lectures talking about salient features in our American system, and the idea that by and large we have relatively little state regulation, what I'm calling ex-ante regulation, and relatively robust private, decentralized, ex-post litigation for things like consumer products and the like. Drugs, pharmaceutical prescription drugs and medical devices are kind of exception to that because we have very stringent ex-ante regulation of those. They're treated very differently from typical products. So the FDA has probably the world's most stringent standards for mandating that prescription drugs are safe and effective before coming to the market. And the issue that's at stake in federal preemption of state tort law is if the FDA, if our public centralized agency has given its approval to a drug and to the labeling on the drug, should a private citizen who is harmed by taking that drug be able ex post to bring a tort lawsuit? So it kind of engages one of the issues I began with, which was to figure out the optimal level of regulation in a society. You want to think both about the public regulator and the role of private tort lawsuits. So let's talk a bit about the facts. The plaintiff in this case is Diana Levine. She's in the picture down here along with her lawyer at the US, all the way at the U.S. Supreme Court. But where does this case start? First, the underlying action is a medical malpractice action, actually, because Diana Levine had gone into a clinic because she had migraine headaches, and she was given a drug called Demerol for her headache, her migraine, and a different drug called Phenergan for the nausea. The issue about Phenergan is that the physician administered this by something known as the IV push method. So the idea is, if you go to the hospital and you're going to be administered this drug, there are two different ways you can get it. One is you get hooked up through an IV that gets inserted into a vein, and then the drug is put into the IV and it drips. That's the IV drip method. That is the safer method. There's an alternative method that's called the IV push, which just means the drug gets pushed directly into your body. And so what happened is the doctor who was administering this drug pushed the drug directly, not into a vein, but an artery. So the medical consequences here, it was negligent, and the medical consequences were severe because Ms. Levine developed a condition known as gangrene as a result of this drug going into her artery, and as a result, the doctors had to amputate her arm. They had to cut off her arm, first her hand, and then her entire forearm. So it's hard to see, but down here, she actually she's holding some kind of feather, but she no longer has her forearm or her hand. To make matters worse, and this is relevant too when we were thinking this morning about how you quantify losses to plaintiffs, she not only suffered this physical injury, but she was a musician. So her source of livelihood was playing guitar. She's right-handed, and so losing her arm was serious, not only because most individuals want to keep their limbs, but because it was the source of her making her living. She brought a medical malpractice claim against the health center and the clinician, and those actions settled. So again, the lesson here is it's a fairly typical scenario in the United States where a patient is injured by the negligence of doctors and clinicians at the clinic who made a mistake or an error in how they administered the drug. They settled. Each of those parties had insurance. They had medical malpractice insurance, and they settled with Ms. Levine. So that never went to trial, and she was given $700,000. Now the story gets interesting because Ms. Levine, in addition to having this medical malpractice case, decides that she wants to sue the manufacturer of the drug, who is Wyeth. So that's her products liability case. And she brought an action for damages against Wyeth Pharmaceuticals, who was the manufacturer of Phenergan. Wyeth's defense was, you can't bring this lawsuit. That's what's meant by preemption. Wyeth argued that the fact that the FDA, the Food and Drug Administration, had approved this drug and approved the labeling on the drug means that you, Ms. Wyeth, they argued, cannot bring a damages action against us for failure to warn. And Ms. Levine said that the labeling, which did have a warning, right? The labeling said that if you inject this drug into an artery, you could get gangrene. So it was a warning on the FDA-approved label. But Ms. Levine said it was not good enough, that she should have been warned that this method of doing the IV push instead of putting it through the drip was way too dangerous. It shouldn't have been allowed. So notice that what Wyeth is trying to argue here is the FDA has approved this label, and there might be problems with it, but you, a private citizen, shouldn't be able to come in and say that we're responsible, that we, the manufacturer, are responsible. Drug manufacturers in the United States can't change their labels on their own. They have to do this in conjunction with the FDA. So Wyeth argued that it would be impossible. There's a form of our preemption law that's called impossibility preemption. So they said it's like we're between a rock and a hard place because we'll get in trouble if we deviate from the FDA-approved label, but the state law is trying to tell us that the label's not good enough. Okay. What happened in this action? So Ms. Levine argued that she incurred very substantial medical expenses. This, again, we were talking about this morning, the kinds of things that she would put on as evidence. She lost her livelihood as a musician. She was, actually the picture down here shows her, it's not very clear, but it shows her playing the guitar with a prosthetic, arm with a hook. But obviously she wasn't able to play the guitar as well as she could before. And so she argued for economic damages, and the jury awarded her economic damages in the amount of $2.4 million. So again, this does, I think, show one of the points we were talking about this morning, which is the considerable difference between kind of the size of awards in the United States, even when we're just looking at the economic damages component, not looking at, pain and suffering awards, punitive damages. She also, though, argued in addition to her economic damages that she was entitled to non-economic damages. And she made a claim here for $5 million. She said that the sense of despair surrounding the accidents was amplified by the fact that now she could no longer enjoy playing the guitar, that all of these things were not captured by the lost wages, the economic component. So she asked for $5 million in non-economic compensatory damages. So the jury awarded a total here of $7.4 million and gave that to Ms. Levine and awarded that against Wyeth. As I mentioned, Wyeth argued federal preemption. They said that we shouldn't have to pay any of these damages because this is a product regulated by the FDA, and the FDA, when it approved Wyeth's application for this drug, had deemed the warnings that were on the label to be sufficient. So Wyeth made this argument that the FDA's having approved the label and the warning preempted or ousted the state tort law claim. In other words, we should leave this regulation solely to the public regulator. We have very stringent ex-ante regulations on drugs, and so individuals who think that the warnings aren't good enough should not be able to bring tort lawsuits. The U.S. Supreme Court disagreed with this. This was a very controversial and close decision. It was a 5-4 decision. And what they decided is that Congress, right, because Congress is our national legislature, when they had passed the FDCA, which is the Food, Drug, Cosmetic Act, that's the national legislation that authorizes the FDA to regulate drugs, they said that they didn't intend for this system to preempt or oust state tort law. So 5 justices of our Supreme Court think that even when it comes to an FDA-regulated product, something that has very stringent ex-ante regulation, victims should nonetheless be able to bring tort actions for failure to warn against the manufacturer. You can imagine that this ruling led to an onslaught of additional claims that plaintiffs' attorneys were bringing against the manufacturers of FDA-approved drugs, saying that they had failed to warn adequately and the like. And it's an interesting posture. The court has struggled with how far to go with this. And in fact, just to add one final complication, the U.S. Supreme Court decided a next case against not a brand name manufacturer, but a generic drug manufacturer. And it held in that case that you could not bring state tort actions against the generic, that those are preempted. So it's an interesting situation in the United States right now where injured victims who have taken a brand name drug and are harmed by that can sue the manufacturer, but if they've taken the generic version, they can't sue. In some respects, right, this is going to create a lot of controversy because for cost-saving reasons, we have various incentives to try to get people to take generic drugs instead of brand name drugs. But it's as if today in the United States, if you ingest the brand name drug, you're in effect taking a drug with something akin to an insurance policy. It's an insurance policy in the sense that if you're harmed by it, you can bring a tort lawsuit against the manufacturer. Whereas with respect to taking a generic brand drug, you can't do that. So it's a little bit of a strange situation. The U.S. Supreme Court, when they heard that second case against the generic, admitted that it seemed like a crazy distinction that they were drawing, but they said, you know what, Congress can fix this if Congress wants to, because this is just our decision based on the differences in how the regulations, how the FDA regulates these drugs. The idea was the FDA has mandated that generic drugs have to have the exact same label as brand name drugs. And so they didn't want to lead to a situation where the generic might change its label and then be different from the brand name drug. In any event, I think this is an interesting case to sort of bring into focus. There's a sense in which I once thought this issue of federal preemption was wholly unique to the United States. But then I was asked to go speak in various places in Europe, and it turns out that they have a kind of similar inquiry where they're trying to figure out how they should reconcile regulation at the EU level vis-a-vis national law when it comes to things like regulating products. And more importantly, I think, this issue at a deeper level reminds us that the choices that a society makes between how much state control and regulation you want to have and how much you want to rely on private, decentralized lawyers to be bringing private actions to regulate health and safety is a very fundamental question. What this case, at least in my mind, stands for is the United States, while in general, as I mentioned, has very low state involvement, low ex-ante regulation, lots of products liability litigation ex post. In this scenario, where we're talking about pharmaceutical drugs, we have both. We have very stringent ex-ante regulation, and we also allow ex-post litigation. In other words, our system has evolved to a point where we really believe that the private lawsuits are serving a necessary function in terms of appropriately deterring product manufacturers, even manufacturers of pharmaceutical drugs that are facing very stringent state regulation through the Food and Drug Administration. Okay, this wraps up the series of lectures. I wanted in this slide not only to say thank you. I know we're not finished. We're going to be debating some of these questions and wrapping up, but I want to put up here my email address. I'd be more than happy to hear from people following on. It's been my great pleasure that in various places that I have visited to talk about issues of either U.S. tort law or specifically punitive damages or preemption, I have heard back on an ongoing basis from various participants about how certain issues have come to bear in their respective countries. So I think at this point, are we gonna break as usual first, or no? I'm gonna turn things over to you. Okay, you'll tell us what we're gonna do. Thank you.